about 3 now. I think that is a good time to kick it off. We might have some few people leaking in, but I think we have mostly everybody. It's good to see some familiar names on the Zoom. I see Lori Satterfield from Realty Income, who I've known for years since I was a baby lawyer. And Wendy Bolger's on. I used to work with Wendy's husband in my initial stunt as a lawyer, as a litigator, my brief 1.5 year experience as a litigator. So good to see some familiar names on, and looking forward to having a good discussion with everyone. My name is Seth Garrett. I am a transactional real estate attorney at Matkins. And today, myself and my colleagues, Mike Holmes and Jonathan Lorenzen, are going to go over a few different areas and trends in commercial real estate, as we've seen during COVID, and as we hopefully appear to be moving into a post-pandemic world. Kind of what does that look like? What kind of lessons learned do we need to heed going forward? And just some good general working knowledge of leases and different aspects of trends in real estate. So I'll kick it off. I'm going to kind of get going here, since we're splitting it up into 3, so we each have about 15 or 20 minutes each. But feel free to interrupt me if you have any questions, or we can save questions for the end. So a little bit more about me. I started my career before law school as a commercial real estate broker. So I was a commercial real estate broker in Phoenix, Arizona, and I went to undergrad at the University of Arizona. So I see my colleagues are dressed sharply, and I'm the scrub in my University of Arizona shirt, because we have an important basketball game tonight. So I don't know if any of you are doing brackets, but hopefully you have Arizona going at least by past Houston tonight. So I transitioned and became a law student in San Diego in 2010. And so fast forward 11 years later, I'm an attorney and a transactional attorney at Matkins, and have a broad-based commercial real estate background where I handle a wide array of commercial real estate transactions and product types. I have a particular emphasis on commercial leasing, which is what I'm going to focus on today, and from the perspective of both tenants and landlords. And as a recovering commercial real estate broker, I try to take a practical approach to negotiating lease terms. I know that speed to execution is critical, and I try to bring my deal-making knowledge and expertise gained on the brokerage side to best position my Matkins clients for advantageous legal transactions. So today, my portion of the presentation is going to be tips on how to best negotiate, renew, or protect your lease terms. And as I mentioned before, we did this presentation, a similar presentation to ACC about 6 months ago. And, since we last gave that presentation in September, we now appear, fingers crossed, to be heading into a post-pandemic world where we have, less restrictions, and, people are returning to work, and kind of what does that, new normal look like for commercial tenants and landlords. There was, that being said, I think there was a lot of valuable lessons learned, during the pandemic, a lot that were learned on the fly by both sides. And I think they're good to keep in mind moving forward, when you're negotiating lease terms. Hopefully we don't, find ourselves in another COVID scenario anytime soon. But, there could be something in the future where restrictions are present, and it's affected businesses that, force tenants and landlords to shift, what their existing lease terms are. So next slide here. So just as an overview, COVID-19, as we all know, disrupted all businesses, but the impact varied greatly depending on the type of business. Some retail tenants were hit very hard, where people weren't going out and shopping or going to restaurants. Industrial seemed to thrive based on, no customers really being present at the locations, and e-commerce becoming even more important during the pandemic. Office, took a big dip just because people weren't coming into the office. That's not to say that the office tenants weren't successful in their own businesses, but as it pertains to their real estate, we saw a lot of empty office space where people just couldn't come back to work until vaccines started to kind of come into the normal play, and people are now starting to return to work in droves as a more safe, experience. And what does that mean? Do tenants need more space? Do they need more space for their employees to spread out to feel comfortable? Do they need less space? Are certain tenants becoming, full-on remote work from home? It varies greatly on the type of tenant. So during the pandemic, we saw a lot of rent relief and extended lease terms, and I'll get into that more next about kind of lessons learned to keep in mind moving forward with different strategies. But there was also eviction moratoria in place. And I just wanted to make a note on kind of the status of the eviction moratoria in San Diego. And I spoke to one of our litigators yesterday. So as of the last time I checked, there's no eviction moratorium currently in place for commercial tenants in the city of San Diego. Commercial tenants who were entitled to rent deferral under the prior moratorium had until December 31st of 2021 to pay all their back rent. And landlords were prohibited from endeavoring to evict those tenants based on non-payment of such rent until January 1st, 2022. So we're a couple months past that. That said, the moratorium expired on June 30th, 2021. So looking back, if a tenant failed to pay rent after that date, the landlord could send the tenant the 3-day notice to pay or quit based on the failure to pay that particular portion of rent, and bring a unlawful detainer action if they fail to comply. So I think, eviction moratoriums are in the rear view, and that's kind of the state of eviction moratorias in San Diego County. Now it's different from county to county, so that's just speaking of San Diego. Work from home policies are changing the ways business function. As I mentioned, the need for space. Do we need less because we have less employees that are coming into the office? Or do we need more space? Do we have people coming back, but they aren't comfortable unless there's more space between them and their fellow colleagues? So it's changing on the office footprint. What those leases look like and what the need for space is. We saw a lot of lender implications as well during the pandemic. If there's lenders that have loans on properties where there's a landlord in place and a tenant, that's a three-party transaction. And so there was a lot of time where lenders were in a wait and see approach about, what's this pandemic going to do? And if there was any modifications to leases, sometimes that would affect the underlying deed of trust as well. So three-party transactions were added another wrinkle to renegotiation during the pandemic. So next, I'm just going to touch on the legal rights of tenants, and this is kind of just lessons learned for the future. We heard a lot during the pandemic about force majeure, which I'm going to go into more detail before I wrap up. But kind of what does force majeure mean? How it's practically employed, and what can tenants and landlords do about it? What's the access to the premises like? I know when the pandemic first hit, during first couple months of second quarter 2020, sometimes certain tenants couldn't get access to their premises. So what does that mean in a lease? Was there an interruption of essential services? These are all buzzwords in leases, and these are legal rights that tenants have in their lease. And then governmental action, right? What overriding governmental action, stay-at-home orders, were in place that would prevent a tenant from coming into work and occupying their office space. And what's that mean? So I think the key takeaways and lessons learned for the future in the event, something like this similar happens down the road is just as always, communication, right? Being a good tenant, being upfront and communicative with your landlord, and vice versa, right? If you're a landlord, being upfront and communicative with your tenants. I know that I worked with a handful of good landlord clients who were very proactive in reaching out to their tenants in April of 2020, when the restrictions came into play and everyone was kind of learning on the fly. So I think tenants should be proactive, and reasonable with their landlords. And then, I think we're done with the eviction moratoria, but there could be new legislation that comes forward to change current legal contractual obligations. There's a lot of COVID cases being litigated right now or mediated, so we really won't know where those cases shake out for, probably later this year or maybe years in the future, depending on how long and how protracted that litigation is. Business interruption insurance was a big takeaway from the pandemic as well. Who had it, who didn't have it? Were the policies able to be, drawn upon? Something for tenants, risk management's team to consider when they're renegotiating their lease. So the keys there are transparency and fairness, both sides. So some tenant renegotiation approaches. These are some strategies that were pursued by certain tenants during the pandemic that we saw in order to relieve short-term cash burden during a period of disrupted revenues. And these strategies required an arm's length negotiation using legal counsel between landlord and tenant outside of the legal obligations stipulated in the existing leases. So, depending on the tenant, which I'll kind of get to later on the preliminary considerations, these were, I think I would say, the main strategies to relieve, short-term burdens, cash burdens during the pandemic. We had rent forgiveness, which was, given, rent or partial rent forgiven for a short period of time. Rent deferral, and tenant receives free rent for several months to be paid over a period of time once the operations resume. So you get some free rent up front, but then the balance of that free rent is amortized over the back end of your term. We had month-for-month extensions, whereby tenant got free rent for several months in exchange for the same number of months added to the back of the lease term. We had blend and extend options, where the tenant received free rent for several months in exchange for adding a longer period of additional term. And then we also had the early full extensions, right? So this would be a renewal for a full term with temporary rent relief, as part of the package. So, it depends on who the tenant was, who the landlord is, what's the credit worthiness, all that stuff was, brought into consideration when you were talking about the different tenant approaches. And, we can talk about preliminary considerations too. These are all brought into play when you're looking at different approaches to get some short-term relief from rent. Accounting and refurbishment, the right size of the space. We talked about a little bit earlier about, some tenants needed to downsize their square footage. Some tenants needed to upsize their square footage. So converting the existing space into appropriate and optimum size. Credit enhancement, there could be an existing security on the lease that needed to be enhanced, whether it's additional security or a different type of security enhancement. So it could be, a letter of credit in addition to a security deposit or a personal guarantee. Timing is an issue, and then leverage, right? So each component is unique when you're looking at a deal, right? Who's the tenant? Who's the landlord? What's the market? What does the underlying lease language say? Is there a lender? Those are kind of the main questions you ask yourself with every deal, right? I mean, you take a tenant like Starbucks, you know, super credit worthy, and then you have a mom and pop retailer who, you know, might be, you know, floating by month to month, you know, different amounts of leverage on each side there for the landlord to consider. So those are all, you know, considerations that the parties need to take into play when they're coming to the table to try to renegotiate terms. So during the time when a tenant would ask for some negotiation, the landlord's going to ask the tenant for certain information, right? I think there was an issue during the pandemic with certain tenants asking landlords for rent relief, when, you know, sometimes the tenant, you know, honestly didn't really need the rent relief. It's sure nice to have, but I think the landlord wants to have some semblance of evidence that you actually, tenant, are in need of this rent relief for however long you're asking for. The landlord could ask for financial information and other information that demonstrates that the tenant's unable to pay the rent. Confirmation from tenant's insurer, so, you know, business interruption insurance, whether it covers, you know, documentation for government assistance. You know, during the first year or so of the pandemic, that was a big thing, right? Whether you're going to get that government assistance funds, which could, you know, offset any free rent or rent deferral you could get in the future. The landlord could ask for year-end financial statements, balance sheets, year-to-date income statements. You know, I think the main thing, you know, for tenants to not do when approaching the landlord for some sort of rent relief is to withhold rent. You know, we'll touch on briefly next about force majeure. In most instances, it does not relieve the tenant's obligation to pay rent. So I wouldn't withhold rent to the extent you're able to pay it. It could always be recouped later on once a renegotiation is reached, a compromise is reached. But I think that's a big thing for tenants to keep in mind. And like I said at the beginning, you know, not to ask for help unless it's actually needed. So I think the last portion before I turn it over to, I think, Jonathan, is just force majeure provisions in general, real quickly. I think that was the buzzword, right? When the pandemic, when we were in the throes of the pandemic, right? Is this force majeure? Does this prevent a tenant from paying rent? You know, again, a lot of these cases are still being litigated, but I can tell you kind of what we've done during the pandemic with different tenants and landlords, and just kind of how we come to a middle ground. You know, first, I think it's important for leases, whether you're drawing up a new lease or an amendment to a lease, is, you know, define a pandemic or an epidemic in your lease, in your force majeure provision. Sometimes force majeure provisions just say, you know, act of God, you know, very broad. But I think, you know, it's key, especially after the COVID-19 pandemic, to have some sort of definition of what a pandemic or an epidemic is. You know, we use words such as, you know, the Center of Disease Control and Prevention, World Health Organization. You know, if there was a shelter-in-place order, stay-at-home order, if premises have to close for business, if government offices have to be closed, and therefore the tenant can't operate based on that. So I think it's good and better for everyone, you know, to really define what a pandemic or an epidemic means. You know, in the future, if we have another pandemic, then it'll be clear on how that's defined, and then what does that trigger in your lease. So again, no excuse for the non-payment of rent. You know, a force majeure event shall not delay or extend, you know, any rent commencement date or excuse of payment of any monetary obligation under the lease. So I think the worst thing that a tenant can do in that situation is just stop paying. I think you need to let things flush out and then try to recoup that paid rent later. And then actual delays, you know, to the extent a force majeure event like a pandemic actually delays the tenant from doing something under the lease, from performing in a certain way, we had certain remedies built in. And again, I have C, preliminary considerations. This depends on the leverage, right? Who the tenant is, who the landlord is, all that good stuff, right? You know, Starbucks, you know, might have a little bit more leverage than, you know, a mom and pop hair salon, just the way of the world. But, you know, I break it into two big buckets. You know, obviously we slice these up in a lot of different ways, but kind of some two big buckets are pre-rent commencement date and post-rent commencement date. So what happens if a force majeure event like a pandemic happens and it affects the tenant from operating pre-rent commencement date? Sometimes we do, you know, if the tenant is building out the space with tenant improvements, we'll say that the build out period is extended on a day per day basis during the force majeure period. But there's always kind of a cap on what you should put for the build out period or the day per day extension, because you don't want a lease just going on and on forever. And then for post rent commencement date, you know, if a tenant is unable to operate at the premises due to the pandemic or epidemic, so if there's a complete closure of the business and the tenant actually can't operate, then we can get into kind of those rent relief strategies that we talked about earlier: rent deferral, rent abatement, you know, what that means, if there's a cutoff. But I think it's clear, and I think it's fair for both the landlord and tenant that, you know, while there might be a force majeure event occurring, the tenant has to be completely prevented from operating from business within the premises in order to take advantage of, you know, any extension or rent relief packages. So with that being said, I think those are some lessons learned. You know, moving forward, you know, God forbid we're moving forward and not looking back, and hopefully tenants and landlords don't have to fight this fight for a long time to come. But I think, you know, both sides learned some valuable lessons during the pandemic, and hopefully everyone's better for it moving forward. So I'll turn it over to Jonathan, who's going to talk about some TI challenges and how to overcome them.
Yeah, thanks, Seth. Yeah, that's a good overview. Thanks for that. As I'm going through this, I'll tell you when to go to the next page for the slides. So a little background on me. I'm a partner at Matkins, and my practice is entirely real estate and fairly evenly split between leasing and purchase and sale on both sides too. So I have a lot of landlord clients and tenant clients throughout retail, office, and industrial, and also some receivership work. So a pretty good overview of different sectors and how they've been impacted during COVID. So, you know, I'm going to try and kind of weave in some anecdotes and what I've seen, you know, out there in the real world as things as I've unfolded as we go through this. So on to the first slide, just a quick overview, kind of the general topics that I'm going to touch on. First, delays in construction. Of course, that was something we saw immediately at COVID, which has gotten a lot better. Material unavailability. So that just relates to what are we going to actually use in the construction, and how does that impact our timeline to get things done. Third, the contracts, the general contractors. We've seen some tension with the parties because of the pressure placed on contractors, and of course the needs of your user and your owner to get the work done. And then lastly, just some general trends in tenant improvements. And this is also going to kind of track with potential changes in the market, mainly retail. We've also seen some changes in office and industrial, as Seth alluded to as well. So on to the first slide with delays in construction. So of course, initially when COVID first hit, there were a lot of mandates that really closed down what people could do. You couldn't have contractors working close to each other. What's going to happen on the site? And for about, I think, 10 days, people were concerned, but then we realized that no one was really, contractors weren't paying that close attention to some of these rules. They were doing the work anyway. And it, of course, became an essential industry. So that wasn't as critical of an issue as we thought it was going to be. And now I can say at this point, it's not really an issue at all from what I'm seeing. It's, you know, very, thanks, Wendy, no problem. You know, very easy to get in there, get the work done, and the outbreaks really haven't caused much of a slowdown at all. Really what's happened is more of the materials being available and being able to coordinate on the site based on the demand. which I'll touch on a little more later. And the unavailability of contractor or of the contractor or the labor, that's really been a problem. We've had a lot of contractors who've been in such high demand in certain markets, like especially Salt Lake City. I've seen a huge backlog on projects there where just you cannot get your typical contractor in on the job. And the ones that you do want are delayed, months, sometimes 6 months out to really get going. So there's been a huge crunch on just trying to get those contractors, the ones that you want. And then because of that, we've seen pushback on the user tenant side and the leases to where they've said, okay, we know it's gonna be problematic getting the contractor you prefer. So can we go out and choose our own? And I've seen that happen a lot more, to where landlords are more open to using different contractors because they understand that we need to get the job done. We're gonna try and open it up, a little more breadth as far as who we would typically permit. And I've seen more flexibility with the negotiation on that point. To whereas before we would say, you have to use a contractor from this specific list of 4 contractors. Now I'm seeing a lot more flexibility with owners saying, okay, tenant, you can choose, we'll have a reasonable approval right, and just get someone in there so we can get the job done. So that's been a change as far as how that's been negotiated. Then just general delays on those items. So the construction schedule, overall, I'm seeing a lot of changes as far as how we permit projects, how we get the work to commence, and then how those concepts flow through the entire agreement. So I think the simplest approach, which I've seen first, is on the purchase and sale side. So the purchase and sale side, of course, you have a closing, you're done, the parties go their own way, but it still is impacted during due diligence. So for a buyer, you would want to have a much longer period of time to do your due diligence. I've seen permitting periods getting kicked out up to almost a year, whereas before it would have been rare to see that go more than 120 days in a lot of jurisdictions. In particular, I'm seeing that in Nevada, in Utah, and in Colorado. So, and in Los Angeles, particularly in California, that's where I'm seeing a lot of prolonged periods with those. And I know jurisdictions are taking a long time. In particular, actually Denver. So Denver, I know if you have any work there, it's taking up to a year to get permits and certain approvals turned, which used to take 45 to 60 days. So incredible slowdown in some areas. So if you're doing your purchase and sale agreement, you want to make sure you build that in and you have the ability to, fully get those permits, get those approvals, know if you're going to get them to make this feasible, because the market, of course, could change, and of course, get in there and do the project. And that also relates to who's going to be on the job. So is the contractor going to be able to get in? Are we going to be able to have inspections? Do we have the environmental approvals? Do we have the environmental inspections? All these things start getting backed up. So when I represent a buyer, I'm trying to push that out as far as I can. I'm trying to really pay attention to my consultants to make sure if they say it's going to take 220 days, we put in 240, just to really build in that cushion. Because if we can't get people on the site to do what we need to do, we can't waive our due diligence. So something to consider there. And then onto the lease front, of course, with the lease, it's not as much upfront you have to worry about, but of course, it's a much longer term relationship. So when we focus on what needs to get done, the commencement date, the rent commencement date, those are the first things to really think about with the build out. And these similar delays with contractors, with materials, with getting people on the site, those are all impacting leases, albeit on a little bit lesser degree because you're not actually purchasing the property. I think the major shift I've seen there is with rent commencement. Before the pandemic, we would always, if it was a tenant build, a tenant's doing the work, we would always say there's an outside date, and that date is firm. So it's going to be the earlier of when you start your business in the premises, or 180 days after we sign this lease. And that was pretty much in 95% of the deals. And there was very little give on the landlord side. But now that's starting to change a fair amount, especially in retail deals, because a lot of retailers are faced with different levels of permitting, be it an alcohol license, different types of specialized improvements, specialized materials that are coming in from overseas that are not available. And they're telling the landlords, or I'm telling the landlord if I represent the tenant, that we're not going to get these things on time. How do we know? So we really want to make sure we have more of a floating date And generally that's going to be triggered off of when permits are received for specific items of the work. And different parties will negotiate that harder based on how much leverage they have, but that is really where that is going. And I've seen that in a lot of deals. Whereas before COVID, I rarely ever saw that. And I would always advise a landlord client not to agree to it. And with my tenant clients, I would generally tell them that you're probably not going to get it. Whereas now I always try and push for it. So that's been the biggest change with that. So on to the next slide. So related here, a material unavailability. I mean, everyone knows how this has been. If you've had any kind of project around your house, or I've had a fence. It took 6 months to get fencing materials. It's the same thing on a large site, and it's happening throughout the industry, all across the country. Lately, it's improved, but of course, this is due to logistics and shipping, and then the slowdown at the beginning of COVID caused less production. Now we have a spike in demand, and it's been difficult for the industries to catch up, especially within the building industry. And I think we've seen it get better in the last few months. I haven't heard as much noise about materials being unavailable, but I know that some of my industrial clients were having trouble with just really basic materials like steel, drywall, specialized lighting fixtures, things that needed to go into industrial buildings. And those were hard to come by, or they were just taking much longer to get. And actually on that note, touching on force majeure, if you do have a delay, that has been very contentious because we've been trying to interpret, what does force majeure mean? How does that apply to materials? And if you already have a deal that's in place and you're relying on force majeure to give yourself a delay, it's potentially going to be a fight. So I always advise clients in that situation to really try and think about, what's the delay going to be? What kind of materials are going to actually cause the delay? And let's figure out a realistic timeline now so we can avoid that ambiguous argument that is probably going to be uncomfortable and just, kind of irritating to be constantly sending notices to parties, whether or not you're on the landlord tenant side. So getting better, but still seeing that quite a bit. And then substitution materials, tenant delay with that. Yeah, same sort of thing. And I'll speak to the retail world as well. So retail, there's been a lot of delay on specialized fixtures coming from China, and in particular with restaurants. So it's not as much your bulk materials like your steel, your drywall, just random kind of fixtures you could find at a building supply store, but really specialized types of fixtures and improvements that interior designers and restaurateurs really want in their space to give that environment. So I've seen a lot of tension with that, to where you want to get the restaurant in, you want to get this operator who knows what they're doing, has a really nice space, but they come to you and they say, hey, look, our supplier is getting this from China and we simply cannot get it for 6 months. And we're afraid of trade tensions and shipping. So I know one case in particular, the materials were on their way to San Diego through the port of LA, but they were on a ship outside of the ports of Long Beach and LA for months. And there was a delay with getting those materials off the ship, onto the trains or the trucks into San Diego to finish the build out of the pizza restaurant. And it delayed negotiations. And actually it came up before we signed the deal. So we were able to somewhat delay, or the tenant maybe intentionally delayed signing because they saw that coming, but it was a problem. And had we signed the deal earlier, before we knew that, we would have had to revisit and amend it and probably push back those dates. So very real problem. Then increased costs. So another major negotiation point. I'm seeing a lot of creative requests and asks about how to structure work letters. Before it was pretty clear cut. You have a landlord, a turnkey, they build out the space. That's more typical in office. Or you have more of a tenant build where the tenant really just runs with it, and that's more typical in retail. Now I'm seeing that mixed up between the two more than ever. And on the office side, I'll see a tenant push for more control because they're telling us that they can get it done sooner. They don't agree with our timelines, and there's tension with when rent's going to start. So a tenant will say, okay, fine, I have my contractors, I'm a sophisticated tenant, I have, these offices all across the country, my real estate team can take care of it. So then we get into negotiation as far as, okay, how much control are we going to give the tenant on the landlord side? Because typically in a landlord controlled office building, we would want more control over that space because most landlord owners know that sort of build much better than the tenants, but it's changing. We're giving tenants more control, and as a tenant lawyer as well, I'm getting more control for some of my clients to do that build, and they're confident they can get it done, and it kind of spreads the risk. And then in retail, the inverse is happening. So typically in retail, the retailers are the more specialized users. They would be able to control it and say, we can run this build. But I've seen some who don't want to take on that risk because they're aware of these problems we've talked about. So they're letting landlord take over more. And I'm seeing more blended constructions to where construction projects to where landlord is doing certain portions of the work and schedules that they maybe wouldn't have done as much of 2 years ago. And the tenant is kind of instructing them as to how they want it. So then that means we're negotiating up front a lot more of those details. And it's making the work letter and that whole process a lot more complicated, but it's what's happening. Okay, the next slide, please. So the contracts of the general contractors. So the tension that we've seen with timing, this is all flowing down to the contractors because of course they're aware of the risk and everyone's trying to protect themselves. So I think overall, when you're negotiating with a contractor and thinking about, how best to run this deal, you need to think about spreading the risk, who's going to be paying for increase in materials and labor if they do fluctuate, because of course, with inflation, we're seeing major changes. So think about how you lock in a price on a material or labor contract, and then what happens if the deal goes sideways. I don't see that being as much of a problem as it was a year and a half ago, or as much of a concern, but I still am seeing a lot of negotiation with indemnity and with liquidated damages because, of course, both parties want to try and limit their exposure. So that kind of quick overview of what's happening to the contractors. And then the delay concepts in the construction contract with the work letter. It's something that is important to consider regardless of what side of the deal you're on, because of course the contractor's pace of work is going to drive the deal and when everything gets done, whether you're buying property or if you're a tenant or you're a landlord leasing it to a tenant. So you want to be aware of that, you want to be cognizant of the challenges they're facing, because whether you acknowledge it or not, or whether it's really your concern, it will end up impacting the timing. So I think that having the open discussions with all the parties, talking to your contractor, talking to your tenant, your user, your landlord, whoever it may be, and really understanding those timelines up front is a good idea. Because if you try and hide the ball and simply look after your best interests, it might end up being much more contentious than it would have had to have been. Okay, on to the next slide, please. Okay, and the trends and the tenant improvements. So office leases, and we've seen these changes for the last, I'd say, like 4 or 5 years. Open concept was a huge thing, of course. Everyone thought it was to be very collaborative. We can fit more people in the same space by knocking down the walls, not doing those as extensive build outs with individual spaces. But that has sort of changed. I don't hear much talk about open office spaces as much at all. But one caveat, one area where I am seeing more of those on space plans and leases is for a hybrid work scenario. So where we could be going with this is we have individual offices, we have people using these offices, but not necessarily a greater number of individual offices, but perhaps more shared spaces. So people that are working in the office 2 to 3 days a week will have a shared space instead of a necessarily designated office that is theirs with the name on the door. So I think that's the direction that things could be going. And the space for social distancing, that's somewhat being reflected in the size of the common areas and the size of hallways. So I'm seeing floor plans moving in that direction. So to summarize, open concept overall, not as popular. We're having some individual offices, but we're also having a lot of shared spaces and then larger common areas and larger hallways for people to gather, which seem to be more acceptable and feel safer for people. So that is that. And then see the trends and tenant improvements for retail and restaurants. So retail generally, there's been a lot of talk for a few years now about brick and mortar, what's going to happen with that. And it really hasn't been as much of a doomsday scenario as you might want to believe. Actually, COVID injected a lot of life in some centers that previously were not doing as well. So some of your of course, your A-class centers with a Costco, with a a major tenant, major anchor, they did great. Even some of your B and C class centers that have a important user, important services for people who are living close to them, because now they're working at home, are using these centers a lot more than they used to. So I've seen some big changes and increased value actually with some of these projects that maybe before would have been overlooked. And maybe you would have said, well, smaller inventory, everyone's doing it online, but not really. People are still going to CVS, they're still going to the grocery store, Costco, Walmart. You're seeing these kind of users, and of course, fast food, like the one in the picture there. And I have some clients that actually do similar operations who are doing better than they ever have. And it's a direct result of COVID. And since we thought through these slides before, in the last few weeks, I've seen even more changes due to inflation and restaurants. So I predict that probably, I say the next 6 months to a year, if prices keep going the way they are, the sit-down restaurant user is going to be squeezed. And we're going to see an increasing uptick with fast casual dining. We've already seen it happening. And I just know anecdotally that a lot of people are doing that. You go get your bill, used to be $30, now it's $70. You still want to go out, what are you going to do? You're going to find a cheaper option, generally fast casual. So there's been a lot of growth in that sector, and I don't see that stopping. And then with the restaurants, the outdoor dining, less emphasis on dining rooms for fast food. So outdoor dining, that's obvious. People feel safer with COVID. The dining rooms for fast food, though, one thing that I want to point out there is that we've seen a shift to drive-through only options, to where restaurateurs are now realizing that they don't even need to have a dining room. You simply have a queue with cars and it works out great. And that business model was really not as prevalent, especially 10 years ago. It started to uptake a little before COVID, but we're seeing it a lot more now. A lot of drive-through only type operations. Okay, then I think that's it. That's it for me. So now on to Mike Holmes.
Hey, thanks, John. Appreciate that. That was very interesting. Both Seth and John, very informative. Thanks for going over those topics. My name is Mike Holmes. I am a real estate transactional partner here at the firm. And I actually have a litigation background as well. I, in fact, was a litigation partner here at Matkins for many years, but I am now doing 100% transactional real estate. But with that background, obviously that litigation viewpoint is part of my practice. I can't get rid of that litigator voice in the back of my head while I'm doing my deals. So I think it serves me well to have that perspective. But I'm going to talk a little bit about service animals and the ADA Disclosure Statute that we now have in place, have had in place for a few years. And I titled this, like Seth said earlier, we did this about 6 months ago, and it's back when I thought we were all coming out of this. So fingers crossed, we are actually coming out of this now. The title, "Everyone's Back from Quarantine with Their Dogs and Their ADA Attorneys." I mean, that comes from the fact that now we are starting to really see people come back and engage and be part of all the different resources that are in our community, and that comes with good and bad consequences. I mean, it's great to have the businesses flourishing, of course, but also a consequence of that is that people are having access issues, and that results in disputes regarding access. It also, unfortunately, and if any of you have heard me speak before, and then this goes back to my litigation background when I used to litigate these cases, unfortunately, we do also have a lot of ADA plaintiff attorneys that take advantage of the situation and give a bad name to true access claims. But we're seeing that as well start to pop up again. So that's the background on that title. You know, we are starting to see a lot more activity with service animal and ADA issues pop up. So service animals, you know, service animal must be trained. There's a little, I think the service animal is, there's a lot of misconceptions about them, not only by employers and landlords, but also by folks who have them, who own them. A service animal it must be trained to take specific action when needed to assist a person with a disability. A common example is a dog who guides the blind or alerts people who are deaf. Another example would include a person with diabetes that has to have a dog trained to alert them when their blood sugar reaches high or low levels. Or a person with depression, they may have a dog that's trained to remind him or her to take their medication. Those type of tasks that are related to the person's disability. The task or tasks performed by the service animal must be directly related to the person's disability. Service animals are working animals; they're not pets. So that's the key with that definition. Any breed of dog can be a service animal, but your pet rat or weasel cannot be. Okay, it's limited to dogs. With one caveat, and that is that if they're reasonably accommodated within a particular facility, miniature horses can also be service animals. There's a bunch of factors that go into that, including whether the miniature horse is housebroken, whether it's under the owner's control, whether the facility can accommodate its size and weight. Miniature horses are typically between 24 and 34 inches tall, and they weigh between 70 and 100 pounds. So can be quite larger than your typical dog. And whether the miniature horse's presence will compromise legitimate safety requirements at the facility. So all those factors are taken into account, but they can be service animals in addition to dogs. There's no license, vest, or other documentation required. The ADA doesn't require service animals to wear a vest or have an ID tag or have a specific harness. And even folks who have service animals sometimes aren't aware of that. The owner doesn't need documentation showing that the dog was certified, professionally trained, or licensed, because the ADA doesn't require certification, professional training, or licenses. People with disabilities have the right to train their dogs themselves, so they don't need to license or certify them. There's a limited inquiry that can be made, so it's not obvious whether a dog is a service animal. A landlord or an employer may ask two, and only these two, specific questions. Number one, is the dog a service animal required because of a disability? And number two, what work or task has the dog been trained to perform? The landlord or the employer is not allowed to request documentation require the dog to demonstrate the task or inquire about the nature of the person's disability. They're just allowed to ask those two questions. So how do you know if the need for a service animal is real? Well, in a nutshell, you have to take the owner's word for it. If someone is willing to lie and say that a non-service animal is required because of a disability and that it has been trained to perform a specific task related to that disability, then a landlord or an employer must allow the animal to enter their retail center or their office building. That's just the way the law is written. It's very frustrating, but that unfortunately is the limit of what an employer and a landlord can do. But those questions should be asked, and you should get answers to those if there's any question about whether the animal is a service animal. So I want to talk a little bit about service animals versus emotional support animals. As mentioned earlier, I said that a service animal is trained to perform a specific task directly related to a person's disability. An emotional support animal, on the other hand, does not perform any task related to the person's disability, but rather provides comfort simply by being present with the person. So landlords are required to allow, here's the difference, the landlords are required to allow service animals to enter their retail centers and office buildings, but they're not required to allow emotional support animals to do so. So the difference between the two is key for landlords. However, employers, and this is also true for airliners, residential housing, some other areas, employers have a different standard that often allows emotional support animals. So not in addition to service animals, they often have to allow emotional support animals in the workplace. So there's a tension between the rules for a landlord and the rules for a tenant employer who has a disabled employee with an emotional support animal. The question is, can the employee bring his or her emotional support animal to work? If it's in a building where a landlord doesn't allow emotional support animals. There are no statutes, there's no case law or online resources that address this issue directly. Believe me, I've looked, it's just there's nothing out there. But I've discussed it with several federal and state agencies, and the unwritten bottom line is this: regardless of any obligation an employer may have to its employees, the landlord is not required to allow a non-service animal into its office building or retail center. So where does that leave the employer? Well, the employer can claim undue hardship because the employer is unable to allow its employee to bring an emotional support animal to the workplace, provided that the employer provides another reasonable accommodation, if one exists, to the employee. So for example, an example of a reasonable accommodation might include allowing the employee to work remotely from home, which we've all gotten very used to over the last couple of years, depending on the area of the employment, or transferring the employee to another office, or allowing the employee to bring another item to the workplace that would provide the emotional support that's required by the employee. So those are if one exists, those are different reasonable accommodations the employer can make in the face of the fact that they can't allow the employee to bring an emotional support animal due to landlord's rules and procedures at the facility. So that's all I was going to talk about on emotional support animals and service animals. If maybe this is a good time to take a quick break. If anyone has any questions about service animals, I'm happy to take them now before we move on to the ADA Disclosure Statute. Okay, so why don't we move on to the ADA Disclosure Statute? In particular, specifically, I'm going to be talking about Section 1938, which was enacted a few years ago. So you should already be seeing these disclosures in your leases, probably for a few years now. But I wanted to walk through some of the particulars and unresolved issues with respect to the statute. Unlike other accessibility statutes, Section 1938 requires disclosures to be made in lease documents rather than barriers to be removed at retail centers. So there's a difference. We're just talking about disclosures here. And with how litigious ADA claims have been over the last several years, I mean, we're talking tens of thousands of lawsuits in California alone, and it's usually to extort settlements ranging from $1,000 to $100,000. It's unclear how much litigation, if any, will be generated by this disclosure statute, but it's important for us to understand it. There's a few important differences. We're talking about owners and tenants as parties instead of the disabled public being involved. And tenants may have different objectives. Tenants might want out of their leases instead of wanting to extort a monetary settlement from the owner. So there's a few differences here on how the statute works. The statute applies to public accommodations, commercial areas open to the public, basically is what that means, such as a retail store, a restaurant, my law office. All of these are open to the public, so they fall under the statute. There are different types of CASP reports, and the difference is very meaningful under some of the accessibility statutes that are in the books, but not for the disclosures under Section 1938. Section 1938 applies to all CASP reports. So it's the different types are not as meaningful in this case. So let's turn to the first subsection of Section 1938. It's 1938A. And it says a commercial property owner or lessor shall state on every lease form or rental agreement executed on or after January 1st, 2017, whether or not the subject premises have undergone inspection by a certified access specialist, CAS. Usual disclosure under this subsection is that the premises have not undergone inspection, and that's usually the case, but the landlord would need to disclose if an inspection has in fact taken place. There's a difference perhaps between a new lease and an older lease that's being amended. This statute, as you'll see, the subsection does not address amendments. It just says every lease form or rental agreement. We believe the best practice is to make the disclosure in the next amendment and anytime after a material modification to the space has been made. So that's what we advise our clients to do. It hasn't been litigated. There's no case decision on it yet, but that's, we think, the best practice. Also, you'll notice that this subsection only mentions premises, doesn't talk about the building or the center. So we believe that it's only inspections with respect to the premises that need to be disclosed. But there's a side note here, practically speaking, a CASP that does come in will need to inspect the path of travel through the common areas as part of the CASP's inspection. So that's going to happen as a practical matter in any event. But as far as disclosures go, you just need to focus on the premises. There's also been, I often get the question about city inspectors versus CASP inspectors. A city inspection is just not the same as a CASP inspection. City inspectors, they don't know the law, they're not held accountable, and the city inspection simply doesn't qualify as a CASP inspection. There is a lot of new construction out there that doesn't comply. And so we see this all the time. If someone is relying on the city inspector, you do so at your own peril. So it's unfortunate, but it's true that even new construction can have these lawsuits brought, and these disclosures are still required. So the next subsection is subsection B under section 1938. And it reads, and I know we're running short on time here, but I'll just get through this one and maybe we can open up for questions. It reads that if the subject premises have undergone inspection by a CASP and there's been no alterations, the commercial property owner shall provide a copy of any report made by the CASP. So this is not a disclosure in a lease form, and there's a couple other subsections in here that have the same approach. It's instead you're dealing with a document that needs to be disclosed. So if you don't deal with this disclosure regularly, you may want to make a note in your form that the report, if it exists, needs to be provided. You'll notice that it's conditioned on no alterations that have impacted the premises compliance. If there have been, then I think the statute presumes that the CASP report may be outdated, not useful. And then the production of the report falls under the next subsection we were going to discuss, which is subsection C. But you'll see, if you go back and look at the statute, which we probably won't have time to do today, but if you go back and look at the subsection C, you'll see that it does require any CASP report to be disclosed. And again, that's not a disclosure in the lease form, it's an actual document that you would be providing. So you need to probably make a note in your lease form that needs to be provided. The owner can require an agreement from the prospective tenant that the CASP report remain confidential, and that is expressly stated in the statute. So when you're disclosing these documents, you can make sure that they are confidential. I will just touch on one last thing before I know we have to kind of wrap it up here. If we move to, sorry, Seth, I know it's very confusing. But if we stay right there on D, this disclosure talks about if the CASP report meets applicable standards, the owner must provide a copy of the current disability access inspection certificate and within 7 days. There's C, which we kind of skipped over, but it allowed the tenant to rescind the lease if the report was not provided to a prospective lessee or tenant within 48 hours prior to the execution of the lease. I don't think I even quoted the language, but that's in the statute. And it could be a real consequence to not disclosing the report. Here under D, you'll see that there's 7 days, you get 7 days after the execution. And I think the difference here is that there's a little more time to produce the report, presumably because everything at the premises is compliant. If there was an issue, then I think the statute presumes that the tenant would want to know that before entering the lease and would want to have that report before entering the lease, and gives them the remedy of rescinding if they don't get that report. So that's something to really keep in mind when you're dealing with these disclosures, is there can be some real teeth as far as consequences and remedies to them if you don't follow the statute. And I'm being serious this time, the one last point I do want to raise under the next subsection is there is a provision that needs to be quoted verbatim in your lease disclosure. I put it in quotes there. You probably are already familiar with it because it is the one quoted provision that needs to be placed in all lease documents that have not been have not had a CASP inspection. And so this is the disclosure you'll see most often. But if there are any questions, happy to answer them. I know we're over time. I apologize for that. But if there's any questions, happy to answer them. Sorry to run so fast through that. And I know that Seth and John would join in and say, if anyone has any questions that occur to you after this presentation, feel free to call or email us. We'd be happy to jump on a call or respond to an email with any questions you guys might have.
Hello, Mike.
Yeah.
This is Steve Adamczyk. I was wondering if you could just put the last slide up for a moment.
Sure.
Thanks so much. Perfect. Thank you.
Yeah, no worries.
Yeah, if anyone has any questions about any of the other topics, free to answer that as well. Construction delays, force majeure, the exciting aspects of legal language.
We appreciate everyone, taking a little bit of time out of their day to join us. I know everyone's busy, so feel free to shoot us an email or give us a call. Happy to answer any questions that we didn't go over today, or if something pops up in your brain later, just let us know. We're always here.
Definitely.